Debra Family Channel. If you have not subscribed, please click the like button, share and subscribe. It's free.
Zakaria Olifir, aged 60, William Musora, aged 40, and 19-year-old Rudolph Divet appeared briefly in court. Police initially arrested Olifir, who owns the farm, and Divet, who is the farm employee, on Tuesday. Musora, who is a foreign national, was then apprehended on Wednesday. Preliminary reports indicate that the remains of the two women were dumped inside the pig stalls. The victims' families are reeling in shock.
We kept on asking about her whereabouts. On Tuesday, she was found dead with a gunshot wounds inside a pig enclosure. Her remains were kept with the pigs, so this is painful to us. She left 4 children. It hurts. We have never seen something like this.
We called to come to the farm to check the situation which had just unfolded. They found the remains of their loved one in the pig's enclosure. The pigs had already started consuming them. This means that the suspect wanted to dispose of the evidence.
And the state is ready to proceed with the bail application, and we are opposing that they be released on bail.
Good morning, Your Worship. I do confirm my appearance on behalf of accused number 2.
Good morning, Your Worship. I confirm my appearance on behalf of accused number 3.
That's a good business. Morning, Your Worship. Your Worship, I just want to make certain if I heard correctly, but because before we proceed, we just need to determine the schedule from the onset. The schedule was agreed that we had an informal discussion with my own colleague this morning, and there was a specific indication that one of the charges would be premeditated murder. Now, on record, it was only read as murder. So, if it's premeditated, then it goes to 6. If it's murder only, then it's 5. So, I just want maybe just to clarify, and then I will address the court on that. Just to clarify exactly.
For suspicious, they are premeditated murders. The 2 murders are premeditated murders. They fall under Schedule 6.
That's a good business. Just to be clear, it was
And
not
further, doctrine of common purpose applies.
Thank you. Now we know what we are dealing with. Thank you for that, Advocate. Now we know exactly what we're dealing with. Well, Your Worship, just to place on record, in terms of accused number 1, I was only able to consult with my client this morning. It was quite a difficult excursion to attempt to consult with him previously. I can confirm that I've been granted the opportunity and I've consulted in full. And as a result, I would like to just place the following on the record. Firstly, Your Worship, it's my understanding that my client made a written statement whilst being incarcerated. Such a statement was made. I would like to place this on the record from the onset, without his rights, his constitutional rights in mind. At no point was he ever awarded the opportunity to call his attorney, and I was not aware that he made any statement up until I consulted this morning. It's quite concerning, and I will deal with it at a later stage. What I also need to place on the record is that as a result of that, Your Worship, in terms of accused number 1, due to the fact that we only obtained instructions, clear-cut instructions from our client directly this morning, we are not in a position to proceed today. The accused persons may be seated. As a court, just to catch our line of address again, Your Worship, I was just indicating that we, in terms of accused number 1, we are not ready to proceed, seeing that it requires a formal bail application, as indicated now by my learned colleague. It is a opposed application. I would like to be granted a proper opportunity, firstly to further consult with my client, and secondly just to have a proper opportunity to prepare and fill up the bail affidavit that I've already prepared for today. Right. due to the fact, and the information that was given to me now, due to the fact that there was a statement now, a formal statement given by my client, while he was not represented, without the benefit of proper knowledge of the eventual, let's say, impact of such a statement on his case, I would like to implore the court to allow me input into the document now, or access to the document. But I would like to, from the onset, give an indication that I believe it will be opposed this morning. But in order for us not to drag this matter out, I will just simply state the following. I am fully aware that the provisions of section 60, subsection 14, is clear, and that it indicates that in a usual circumstance, no one is just automatically granted right to access to the document, to the investigative document. However, I would like to just very briefly refer the court to section 335 of the Criminal Procedure Act, which reads as follows. A person who makes statement entitled to copy thereof. Whenever a person has in relation to any matter made to a peace officer a statement in writing or a statement which was reduced to writing, and criminal proceedings are thereafter instituted against such a person in connection with that matter, the person in possession of such statement shall furnish the person who made the statement at his request with a copy of such statement. And the reason why I'm imploring the court and referring to realise the application of 335 and in referring the court to that specifically is, I am not applying for the full docket. What might be on the docket at this stage, we don't know. But I only want that statement. So I implore the court as well as the state to realise that there's no, if you want to oppose, I'm ready to proceed, but to oppose something that is rightfully already recognised in the Criminal Procedure Act as a right, I don't think we're gonna run around in circles. I can respectfully refer the court to section 34 of the Constitution, as well as the commentaries, specifically the commentaries of Van der Merwe 2001 SCA CJ 297. For the sake of the court, my own colleague, Van der Merwe 2001 SAC J 297, where it's an extensive journal, but I'll just read the relevant sections to the court for the record, where section 34 of the Constitution is clearly deemed to be applicable, and it's confirmed that such, if it's the statement only, there's no real reason for opposition, in my respectful opinion. It is argued that in terms of section 34 of the Constitution of the Republic of South Africa, which is Act 108 of 1996, a bail applicant has a constitutional right to a fair bail hearing, and that access to his section 335 statement is necessary to secure such a hearing. Access to a section 335 statement ensures that there is equality of arms, and I'd just like to indicate to the court, it's a strike that whenever a witness is called and made an affidavit on which the state will rely, let's call it a bail witness for the state, they have the opportunity to peruse such an affidavit and to refresh their minds. So, on that basis, in a further argument, an amplification of the validation for my request, I refer the court to that fact, that it would be unfair that one witness of the one party is allowed access to an affidavit or a statement to refresh his mind, but the other party cannot do so. And secondly, I will also just refer the court to the fact that section 335, subsection 1 of the Constitution deals with how evidence is obtained, well, section 35 in broad terms, how evidence is obtained and the validity thereof. And I have to place on record, it's massively concerning that the SAPS went ahead and proceeded to obtain a statement from a person that's detained in their custody, knowing full well what the implications of such a statement and the fact that he is not represented or allowed to call a representative will have on the case. I cannot fathom why, but things happen in the heat of the moment, I do understand so. Lastly, Your Worship, just on that, just to indicate where my mind is at this stage. The statement itself relates to a very serious charge. Not only one, but several very serious charges. I would be put as a legal practitioner for the defense. I would be put at a massive disposition if I do not have access to that statement. Effectively, that statement is what, to my understanding, is what gave light to the investigations, and it effectively guided the SAPS quite effectively in the investigations. So, not only is it a necessity for me as an accused, as the defense practitioner for the accused to have insight to that, it will also give me a clear indication of how to assist the accused. And it will put me, and this is very important, Your Worship, it will put me in a position, myself and Mr. Reeler, my instructing attorney, in a position to adequately and properly advise our client in relation to the way forward.
In relation to the way forward with regards to bail proceedings or with regards to the trial itself?
Bail proceedings and the trial itself. Because bail proceedings, obviously, we are now at a post stage. And secondly, the trial itself, Your Worship will note, and maybe I'm running ahead, but exceptional circumstances needs to be proven on a Schedule 6 bail application. One of those exceptional circumstances that might lead to a bail application being granted is the consideration of the intention of the accused to deal with the matter. And I can only advise my client specifically to what is the best way forward if I have a clear indication of what transpired. Effectively, that is the best version for us to consider our position. And I will leave it at that. I believe that it will be vehemently opposed this morning, but I have to just take a step back and reiterate after all of my submissions this morning. I'm only looking for the statement. And it is common cause that statement was made at the SAPS while my client was in custody and control of the SAPS, and it was made to a peace offer. So all of the requirements of Section 335 is met by this request this morning. I'm not looking at the whole docket. We will be here for days if we have to fight about that. I simply want the statement, as the court pleases. If there's anything that the court require me to address the court on after my very short submission.
No, just one more thing, just to reconfirm that you're not ready to proceed with the bail application.
No, we are not ready to proceed. It's my express instruction from my client that we need to, in light of the request and further consultations, I need to conduct further consultation with my client. As the court pleases.
Since my colleague was given a chance to read the provisions of the Criminal Procedure Act, may I be given a chance, Your Worship, to read to the Honourable Court what Section 60, subsection 46 regarding access to contents of the docket. It says, notwithstanding anything to the contrary contained in any law, no accused shall, for the purpose of bail proceedings, have access to any information, record or document relating to the offence which is contained in or forms part of the police docket, including any information, record or document which is held by any police official charged with the investigation in question, unless the prosecutor otherwise directs. The prosecutor is given a discretion, Your Worship. This was further decided in S. versus Joseph's 2001, SACR, page 664, C in brackets. It was decided that Section 60(14) vests a discretion in the prosecutor to disclose information or material in the docket. And as of now, as they state, we are refusing to provide the defense with any statement or anything that forms part of our evidential material. The section that my learned friend quoted, Section 335 of the CPA, does not govern bail proceedings. Bail proceedings are governed by provisions of Section 60 of the Criminal Procedure Act. And when the court will be deciding on this matter, it should take into account what the provisions of Section 60 are saying, and not the provisions of Section 335 of the CPA, because they are not the ones that are governing bail proceedings. And Your Worship, since I stated that the state is ready to proceed today, we will appreciate if an order regarding whether we should grant the defense that statement or not may be made today. Since maybe after the order is made, we can be able to proceed. We don't want to waste more time. The defense came here knowing very well that this matter must proceed on bail. It is their fault that they decided not to consult with the accused persons at the police holding cells and decided to come and consult with them here at court today.
Mr. Venter says that he found it difficult, if I'm not mistaken.
Maybe I can be very clear and crisp. I was denied access to the specific details of the matter. I told the patrol prosecutor on a landline. I was informed until such time that she meets me in person, I will not be granted access to information or access to my client. That was expressly stated. And I challenge anyone to that from that. That's the first thing. Secondly, I'm quite sure, I'm not as conversant with this area, but I'm quite sure that the arrest was made at one SAPS station and then moved, and then they were specifically moved to a SAPS station, and we were not informed of such. So I need to place on the record that if I was granted the opportunity to consult with my client, I will not be doing so 15 minutes before a court appearance for the second time. We were not put in a position to adequately deal with this. So I'm not going to be going back and forth with the state on this. But the fact of the matter is, my Lord, I'm not a negligent counsel. I don't come here in a blasé manner. I understand the gravitas of what's happening here. And I understand the gravitas of what this holds, not only for my client, but also for the victims and their families. I won't drag something out if I could have done it earlier in the week. We were not given access. Simple as that. As the court pleases.
My last response, by giving them the statement that they are asking for, our further investigations will be compromised or prejudiced, since the police are still following up allegations that were made by the accused person in that statement. And to some extent, the accused has cooperated very well with the police.
Can I respond to that specifically? I cannot understand the logic of stating that the investigations will be negatively affected. If myself and Mr. Riera, gets a statement of a client, and we can see what is said on that statement, how can we influence anything of the investigation? We don't have access to the docket. We don't have access to the SAPS personnel. We cannot. There's no way that we can have an input to that. So that's just illogical to state that. The fact of the matter is, that statement was and what's very concerning, at not one stage, the court will note, at not one stage, the Berlin colleague denied the fact that the statement was taken. He doesn't deny the fact that the statement was taken without the chance of the accused to obtain legal representation. I might be incorrect, because people make mistakes, but if I understand the standing orders of the police correctly, you have 48 hours after someone is detained to effect the arrest, or to charge a person. So arrest is the process of detaining a person, taking him to a police station or wherever you choose to take him, and then conducting your further investigations. And after that 48 hours, thereafter, you either have to release that person or you have to effect a charge. Fingers need to be taken, and they physically have to charge that person. At that stage, there's no way at that stage that a person can be denied the right to legal representation. That is one of the first cornerstones of our constitution in relation to criminal procedure. So it is now confirmed on record that right was not granted to my client. Now, the state wants to go and further encroach on his constitutional rights by denying him the access to a statement that he made willingly. Apparently, we don't know. I mean, that's shocking, to say the least. Lastly, Your Worship, we came here this morning. My good colleague and myself, we've got a bail affidavit. But certain specific averments needs to be contained in a bail affidavit for it to be considered effective. And we are not in a position to make such averments or to include such averments in our affidavit if it's not accurate. We don't have this information. So how can we come to court now and just file an affidavit? This is not a Schedule 1 simple charge. This is something that affects the community and it affects the interest of justice. Lastly, the court as a statute. This is an institution that's guarded by statutes, and the statutes are clear. The statutory provision clearly states that this is not even something that needs to be argued. It's actually just a process that needs to be completed. So there's no grounds for the state to deny us access to that statement. And it would be highly unfair for us to be put in a position to get that statement at what's it now. It's 10 minutes past 11 on the day that you have to bring in a opposed application. Now you get access to a statement. We don't know the length of the statement. We don't know what's contained in it. We don't know if we have to take further instructions, maybe take a physical look at the scene where it occurred, the incident allegedly occurred. I mean, it would just be not fair. So the court please.
Accused number 2.
Good morning, Your Worship. Your Worship, as indicated by Mr. Reder, he had previously had instructions to represent all three accused, which instructions were then terminated on behalf of accused number 2 and 3. I received instructions to represent accused number 2 on Wednesday, the day before yesterday, Your Worship. I did not have the opportunity to meet and or consult with my client prior to the proceedings today. I did attempt to prepare an affidavit in support of a bail application in terms of Schedule 6 of the Criminal Procedure Act from information provided by third parties. Unfortunately, having been granted the opportunity today to consult with my clients, the information that I was provided with by third parties is not sufficient to proceed with a bail application today. And now, just to address this issue, Your Worship, with the state indicating that it is the defense's fault that we did not consult with our clients prior. If I'm not mistaken, Your Worship, at a bail application, the accused is the applicant, the guider of the process. Now, in terms of Section 60, subsection 11, subsection A of the Criminal Procedure Act, and I will read this in red. Notwithstanding any provision of the Act where an accused is charged with an offence referred to in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his or her release on bail. Now, it is clear that the Criminal Procedure Act states that an accused needs to be provided with a reasonable opportunity to discharge a very high onus of proving exceptional circumstances which in the interest of justice permit his release on bail. Now, Your Worship, also, there's an application by accused number 2 in terms of Section 60, subsection 14, to disclosure of the police docket as it stands. And my learned friend very strategically stopped quoting the Criminal Procedure Act at a very pertinent issue, and I will read the entire section into record. 60 sub 14, correct, Your Worship. Notwithstanding anything to the contrary contained in any law, no accused shall, for the purposes of bail proceedings, have access to any information, record or document relating to the offence in question which is contained in or forms part of a police docket, including any information, record or document which is held by any police official charged with the investigation in question, unless the prosecutor otherwise directs, provided that this subsection shall not be construed as denying an accused access to any information, record or document to which he or she may be entitled for purposes of his or her trial. Now, unless the state is going to allege that the contents of their docket as it stands will not be used at the trial proceedings for this matter, it is clear that subsection 60 sub 14 does make provision for disclosure of the police docket for preparation. And also, to take it further, the Toy et al., the commentary on the Criminal Procedure Act, when considering section 60 sub 14, states the following, and I will read this into record. According to the Constitutional Court, the words "have access to" in section 60 sub 14 should be interpreted as barring physical access to the contents of the docket in the sense of having sight to or perusing such contents. However, it was also confirmed that section 60 sub 14 could not be read as sanctioning an absolute refusal on the part of the prosecution to disclose any information relating to the pending charge or charges. It was pointed out that a prosecutor may have to be ordered by the court to furnish information in order to afford the bail applicant the reasonable opportunity as required in terms of section 60 sub 11. This was also confirmed in State versus Lamini. In furtherance, and I quote, Your Worship, section 60 sub 14 and the court's duty and power in terms of section 60 sub 3 and sub 10, the Constitutional Court concluded that section 60 sub 14, read restrictively as indicated, was not unconstitutional. In State versus Mork is an example of a case. Mork, M-A-U-K, 1999, volume 2, SACR 479W, is an example of a case where denial of access to the police docket resulted in the accused not having a reasonable opportunity as required in terms of section 60 sub 11 sub A to establish exceptional circumstances. At paragraph 489C to D, Judge Snyders found as follows, or it was argued that there's a extremely high onus placed on an accused applying for a bail application, or applying for bail in terms of section 60 sub 11 sub A of the Criminal Procedure Act, read with Schedule 6. And to deny an accused person facing such a bail application and such an onus the right to have insight into the docket may be interpreted in circumstances to deny him a reasonable opportunity to discharge his onus. Because at the end of the day, exceptional circumstances, it is tried law, is proven by 3 cardinal ways, and the only way to address the strengths of the state's case against an accused is to know what the state's case against the accused is. See further Watney 2000 TSAR 369 373 375. And this is also, and I refer to the same State versus Joseph that the state referred to, but also refused or neglected to leave out. State versus Joseph 2001 SACR 664C. at 664C, it was said that section 60:14 vests a discretion in the prosecution to disclose information or material in the docket. It is not an unfettered discretion. Then, Your Worship, the TOI further deals with section 60 sub 14 and the court's duty and powers in terms of section 60 sub 3 and sub 10. Circumstances may be of such a nature that a court is, on the basis of section 60 sub 3 and 60 sub 10, duty bound to order the state to grant the defense access to some information contained in the police docket. In State versus Green and Another, 2006, Volume 1, SACR 603, Supreme Court of Appeal decision by Appellate Justice Farlam, it was found as follows at paragraph 23. It is clear from section 60 sub 10 that the court's function in a bail application is intended to be more proactive than in normal criminal proceedings. As it was put in the Dlamini decision, a bail hearing is a unique judicial function, and the inquisitorial powers of the presiding officer are greater. On a proper consideration of the case on which the state relied, any reasonable court must have concluded that it lacked reliable and important information necessary to reach a decision, notwithstanding that such information was apparently readily available. In such circumstances, the court has no discretion but to invoke section 60 subsection 3. In my view, the magistrate should, instead of refusing bail without more, have ordered the state to grant the defense access to the videotapes and any statements made by the police fingerprint expert linking the fingerprints of either of the appellants with the crime, with the decision on whether or not to grant bail to be made thereafter. Now, Your Worship, from what I have just placed on record, it is clear that yes, the state is vested with the discretion. They do not have blanket authority on that. Now, we've approached the state this morning. We've asked for that access. We were denied. They've exercised their discretion. We now bring an application to this court to make an order allowing the defense insight into the police docket. From my consultation, I was informed by my client that a warning statement was obtained. The police, according to my client, wrote something in the statement he does not know. There is clearly information contained in the docket by the state's own submission that information by the accused is leading their investigation, which is a preposterous notion to begin with. But if that is the case, as alleged by the state, then surely the accused persons who are defending themselves will have to prove to this court that exceptional circumstances which in the interest of justice permit their release on bail should have insight into this information which they allegedly provided, which is leading the police's investigation. Because how else are they going to answer to it?
Your application is for access to the docket in general or specifically to statement made by your client?
To the docket in general, Your Worship. It is provided for by the Criminal Procedure Act, by the decision of State versus Dlamini by the Constitutional Court, by State versus Green, it is not uncommon, Your Worship, and it is not unheard of, especially with regards to an onus this high, and with charges as serious as the state is preferring against the accused, Your Worship. And then if the court wants me to address further on the availability to proceed today, I don't understand. We are seeking a postponement, Your Worship, to have the reasonable opportunity to prepare to present our case, even if, as my learned friend indicated, that an order be made today, whichever way it goes, it will still not afford the defence sufficient time to be in a position to present any evidence today, Your Worship. As a piece of support.
Accused number 2 actually did not make a statement to the police. His only statement consists of only 2 sentences. Initially, after my colleague addressed the court for so long, quoting the Criminal Procedure Act and referring us to several case laws, I even thought maybe she's supporting application by accused number 1. But at the end, she said that they want the docket as a whole. My address in respect of accused number 1 regarding contents or access to police docket contents still applies to accused number 2. We are refusing, we are not going to provide you with the statements that are in the docket.
Good morning, Your Worship. Your Worship, I only received instructions last night at about 9 o'clock, Your Worship. Your Worship, this morning was the first time I had to consult with my client. Your Worship, after taking proper instructions, it's my submission that I would need a reasonable opportunity to prepare to discharge the onus to establish exceptional circumstances, Your Worship, as per section 60 sub 11, Your Worship. Your Worship, this matter is opposed and the charges are very serious, Your Worship, and thus I pray for a postponement, Your Worship, to consult and properly prepare, Your Worship. That's my submission. No, Your Worship.
My learned friend in respect of accused number 3 did not complicate the application by applying to have access to docket contents. As a result, we can give a chance to prepare thoroughly for the bail application.
The court will take a small adjournment to consider the application. So we'll reconvene in 30 minutes for the court to deliver. Of course. And furthermore, on the way forward, there's application by all 3 accused that the matter be postponed for purposes of bail.
We are no longer having an objection since we also want to take the court's decision on appeal. We can agree on the date with my learned friend.
That's what it is. Your Worship, we suggested, or we considered the date of the 10th, being it's exactly 7 days plus 1. It will provide us adequate opportunity. However, now it's now depending on the state and the time which an appeal will take. It will be interesting to see now how long this appeal will take. So maybe we are on the court's hands, alternatively in the state's hands, to get an indication as to how long they would need. Because obviously, I would like the statement, and we cannot proceed to a postponement date because they're not willing to do so. So we are in the state's. I'm in a difficult position. Maybe the state can give us an indication where they want to go with this.
From the side of the court will deliver its reasons by Monday.
And provisionally give it 2 weeks.
2 weeks, if I understand. Let me just confirm. Well, we are in a position, Your Worship, where there's 3 accused. Only 1 accused has got a statement that being my client would want. The rest of the other 2 accused can continue with their bail applications. That's something for the court and the state to consider. I mean, there's no reason for them to be, for their constitutional right to be encroached any further due to the fact that the state now wants to appeal the thing.
must also understand the practicality, because will the state then be calling, I don't know how the state is proceeding in its opposition of the bail, but will the state be calling for oral evidence or viva voce evidence, and then would you respond at one time to all three applications, or in respect of each one differently?
We wanted to respond through viva voce evidence, and we wanted to avoid having to call the same investigating officer 2, twice or 3 times to come and say the same thing, and we'll also be obliged to meet the services of another presiding officer in case one is going to the application for the others.
Your Worship, if I might just address the court on this. There's no reason for the constitutional rights of accused number 2 to be affected by the judgment in respect of accused number 1 and the state's willingness to or request to appeal such order granted by this honourable court. In furtherance of that, the presiding officer that would need to change would be in respect of accused number 1, not in terms of accused number 2 and 3. There was no negative decision made or prejudice towards the state for this court to hear the bail application of accused number 2 in this matter.
The date of the 10th of September, that was suitable for all 3 of you?
Yes, Your Worship.
Would
Accused
that
number 2 can...
the state, then we can postpone to that date, pending then you might, once the reasons are delivered, then I guess the state will also have a way forward with regards to the appeal. I don't know whether the appeal will be dealt with on an urgent basis. I'm not too sure of the time frames there.
It has to be dealt with on an urgent basis, Your Worship. In that case, people will be forced to proceed with bail application of accused number 2 and 3. I want to withdraw what I said, that we proceed viva voce. In respect of them, we will decide whether viva voce or through an affidavit.
So can we postpone the matter then provisionally to the 10th of September for bail? By then, obviously, then we would also have a way forward with regards to your appeal, and then on the 10th, then we'll take it from there.
Can the record just reflect, Your Worship, that all parties then be prepared to proceed on the 10th in respect of accused number 2 and 3, unless on the day there's a contrary indication from the state, so that it's not recorded as a provisional date, and then that is used for justification for a further postponement, Your Worship. Accused number 2 will be ready with a bail application on the 10th.
Your Worship, I'm just fact, I want to play something already. Now, if I understand correctly, the 10th will be then, we don't know what the state want to do. We were accused of not being prepared. Maybe the state must take 2 minutes or 5 minutes, and we can come back and they can tell us what they want to do. Are they going to proceed on an urgent basis? What are they going to do? Because now, if the court provides the reasons on Monday, and I need to proceed on Tuesday, we'll be exactly at the same disposition we were at exactly where we were this morning. So it's not logical. Let's just maybe take 5 minutes, have a housekeeping meeting, maybe myself and the state can just consider how they're going to deal with it, and then we can for the court to decide. Because I've been put in a massive disposition. You asked to make rulings on several things, but we don't know what the state wants to do.
With due respect, Your Worship, it is not necessary to take 5 minutes for the state to decide. The state is still going to consult with its witnesses and decide. Like they have been given an opportunity since they were unable to consult with their witnesses and proceed today. They are being given a chance to go and consult thoroughly with their witnesses. That opportunity must also be given to the state. We will inform them in the morning on the 10th, but we will proceed with bail application in respect of accused number 2 and 3.
On the 10th?
Correct.
I'm inclined to postpone the matter to the 10th. As the representative for accused number 2 and 3 confirms also that it's a deprivation of their constitutional rights. So I'm inclined to postpone the matter to the 10th for bail application. Hopefully before that, the state will have a way forward with regards to the appeal, and the state will need to communicate with the with applicant number one's legal representative.
That's correct.
Then I'm clear, I understand, and I understand exactly what you expect. So then, obviously, accused number one, if I could just ask my colleagues, just give me an indication if I need to drive through, if there's a cost implication, or Mr. Riera, if there will be a postponement to a further date, because Mr. Riera can only attend to such postponement. That's the only request I have, as a court producer.
The appeal will be proceeded with on an urgent basis. I don't know when the decision on appeal will be ready. On the 10th, we are proceeding with accused number 2 and 3. And if the appeal has been finalized with respect to accused number 1, we can also proceed with accused number 1.
Okay. Well, then we understand where we're going with. Thank you for
Unfortunately, at this stage, this court would not be able to determine when the appeal will be finalized.
We are all in a disposition at this time, but we're doing the best we can as a court producer.
So the date of the 10th is then in agreement. Okay, so the matter, Mr. Hammond, is so the matter is then postponed to 10 September 2024 for bail application in respect of applicant 2 and 3 and possibly applicant number 1. All three accused will remain in custody up until then.
Family, what do you think about this farmer who killed 2 ladies and feed them to his pigs? Do you think he should get bail? Why, in the first place, these white farmers are having this kind of a problem with black people? We thought apartheid was gone. Apartheid still exists. When people say apartheid is there, like EFF, Malema, who never shy from apartheid, he always call it by its name. But I don't understand. They have killed these ladies now. 2 ladies, innocent. They shoot them and kill them. Then they take them to feed them to the pigs. Disgusting. I've never heard of such. I used to hear that Boas most of the time used to take people and feed them to crocodiles. But giving them to pigs, and those pigs, you are going to sell them again. What is this? Do you think, family, these people should be given bail? They are so heartless. Family, can you please drop your comment here and let's talk about this. Everybody who comes across this, please just put your comment. I just want to hear your views about this. What is wrong with black people? Why people hate black? You go everywhere in the world, you'll find the same problem. I don't know, family. Please drop your comment and don't forget to click that like button and share and subscribe. Ngiyandithanda ngothando love. Ngithi kunebantu bakithi bravo bravo lapho nikhona khona noma ngabe izindlu zodaka kusekhaya lapha. Bravo bravo.